So this is basically, we stopped on the note that the local administrative land use entity, the land use authority, needs to place on the record their decisions and why. It said, this is what the court said in McElhinney. It's the council's responsibility to define the basis for its decision, not the district court's. Simply stated, if a city council is going to sit as an adjudicated body, it needs to produce findings of fact capable of review on appeal. This Supreme Court case quoted the Wadsworth case. And now we have a case, two more cases that have come out of the Supreme Court on the same issue, one of them this year. So they're focusing on this pretty narrowly, and they quote the McElhinney case. For the lawyers in the room, it's the Monticello Alliance versus San Juan County. And what went on there was that a windmill farm was built or permitted. I'm not sure, was it built or just permitted? We don't know. But it was challenged when the conditional use came up for review. The neighbors together, or others in the community, I'm not sure how they're related, but they were against the idea, and they said the conditional use terms were not being complied with. So they appealed to the Planning Commission to review this, and the Planning Commission said they're being complied with. We're not going to pull the permit or amend it. It was appealed to the San Juan County Commission, and the San Juan County Commission then held a hearing. And the latest case had to do with a decision by the Supreme Court. Did I say this was by the Supreme Court?
Yeah.
This was by the Supreme Court that said that the Planning Commission had failed to gather substantial evidence in the record, and the County Commission could not cure that by trying again. That in this case, the appeal was based on the record from the Planning Commission, and the County Commission could not supplant that record and add more evidence to it to try to bolster it. So we have, whoever's the land use authority, they've got to get it right, unless some appeal process allows for a new record, and that is an option that some counties can apply, but they need to do that in some way that formalizes that there's another opportunity for a de novo review and not a record review. I'm out in the weeds a little bit on that one, but for what it's worth, that's where it goes. The critical thing is that facts are important, not just the facts, but citations to the fact. We will now turn the phone over to Wilf to explain his biggest mistake in land use work.
Yes. This is a situation where I was the planner. I actually worked at Davis County at the time as a planner. The county had contracts with a number of the cities in the county to provide them planning services. And we had a contract with Clearfield City, and I was assigned. And so I was the planner for Clearfield City. You notice the name of this case, Davis County versus Clearfield City. Made for an interesting situation in my life circumstance, being employed by both. But this situation was where over time, you have older houses, grand houses that were built along the streets and so on, and here's the situation. But these houses are getting older, and they're on main streets, and nobody wants to live on the main street. But the houses are still pretty big and still pretty usable. Well, Davis County Mental Health, an agency that provided all kinds of services, including group homes for recovering alcoholics and drug addicts, decided that these two homes along the main street in Clearfield would be great locations for recovery centers, for recovery homes. And so they made the application. The city had listed them as conditional uses in the zones there. So the county mental health department applied for a conditional use to allow those to be located there in those old existing homes. Well, as you can imagine, the city had a public hearing on this, and the room was packed. Oh, was it packed? And the crowd was vocal. And it was pretty much, we do not want this in our neighborhood. This does not belong in our neighborhood. Property values are going to plummet. Crime rate is going to go through the roof. it's going to be a terrible situation. Do not allow for this in our neighborhood. It's a conditional use. During all of the melee that was going on, and because it was such a vocal and interesting crowd, there were several officers there, including the police chief, to keep an eye on things and make sure things didn't get out of hand. And because the chief was there, and a number of people had raised the issue about crime rate goes up around these kinds of facilities, the chair of the Planning Commission asked the chief to come up and said, "Chief, is this true? Does the crime rate go up around these kinds of facilities?" And the chief said, "You know, if they're well managed and well staffed, no, we don't see the crime rate being higher in these kinds of facilities." Well, the hearing went on, and ultimately the Planning Commission voted to deny the conditional use permit. And they said a couple of things. They said, we're denying it because the neighbors don't want it. And we're denying it because the crime rate in these kinds of facilities in the neighborhood goes up. That's because that's what the neighbors said. The neighbors said that. It went on appeal to the city council. The same kind of thing happened with the city council. And ultimately it went to the courts, and I'll let Craig tell you what happened at the courts.
Well, let's turn to page 84. This is before McElhaney by 20 years, but you can see some strains here. Indented paragraph, page 84. Nowhere in the transcripts is there believable information or evidence on which Clearfield City Council could have irrationally believed that the proposed mental health care facility would pose any special threat to Clearfield's legitimate interest. With regard to concern over real estate values, no studies were made, no opinions were given by professional real estate appraisers, nor was any credible evidence of reduced property values produced at the hearing. The opposition did not have factual support in the vague reservations expressed by either the single-family owners or the commission members. Even the commission members. Their opinions are clamor. They're not substantial evidence unless they happen to have an expertise and can speak independently and expertly on a given situation. The reasons did not justify denial of the permit, even though they would have been legally sufficient had the record demonstrated a factual basis for them. The denial of a permit is arbitrary when the decisions are without sufficient factual basis. The consent of neighboring landowners may not be made a criterion for the issuance or denial of a conditional use permit. The opposition of neighbors is not one of the considerations to be taken into account when determining whether to issue a development permit. Not to be taken into account. So, what does a neighbor do? Gather evidence. Provide substantial evidence. I mean, I'm sorry, well, as a lawyer, I'm not sorry, but otherwise, generally, I'm sorry that things have become so legalistic in some cases. But really, there's so much local discretion that if we want to stand up and really influence a local decision to people who know what they're doing, we need to provide evidence, or we need to provide proof that a law is in jeopardy here, that it might be crossed. So the decision is either arbitrary, capricious, or illegal if it's approved. And that's the only role we should play. In fact, there's a narrowing going on to eliminate public hearings and to provide that only those with vested protected property interests even have a chance to speak on the issue. Ironically, in the Monticello Alliance case, Italian pronunciation, the Monticello case, the Supreme Court ruled this January that the people who brought the appeal that was heard by the county commission did not have the right to be heard by the county commission. The people who brought the appeal. And the reason is they didn't have a substantial property interest at risk. They had to have standing. They had to show how they would be individually prejudiced by the issue before they had the right to speak. So this is difficult. And again, the idea is more predictability in the land use process and more more basis in this administrative arena of facts and evidence and less on conjecture. Comment on this?
So really what really could have and should have happened here, I mean, the police chief stood up and said, if they're well managed and well staffed, we don't see the crime rate go up around these. Really, the chief is a credible expert because, he deals with crime all the time. And so he would be considered someone that would be substantial evidence, I think. That would have been a great opening for the Planning Commission at that point to say, okay, we're going to put a condition on this conditional use permit application for staffing, for hours of operation, for the time that the staff has to be on the property, various things that would address those items to try and mitigate that impact. But they actually cited the citizens or the residents as the evidence for turning it down, and the court said they're not credible experts. You can't base it on that.
Thanks. And by the way, on what I just said about what I thought was a surprising reunion, surprising opinion, in my opinion, by the Supreme Court. Of course, I understand it better as I think about it, but the thing is, they didn't have the applicant on the appeal did not have the right to be heard in the ordinances, so they wouldn't go to the common law to find that right. It is very much up to local government, if they wish, to provide for opportunity for public comment, public hearings. That's certainly appropriate. It gets us off down the path because sometimes we want to provide an opportunity for the public to speak simply because we know the public wants to speak, but it puts us in the situation where often we still have to make the right decision in the face of that kind of spirited opposition. But the bottom line here is that this again is up to local government. If they want to involve the public in the process of administrative review, they can, but there are few, if there's any requirements in state code for an administrative decision to have any kind of public process involved beyond the need to do it in a public meeting. We have a microphone.
I'm loud if we don't.
I can repeat your question. Go ahead.
So, Mr. Summercorn, you just made a really interesting thing about hours of operation, how many staff on hand, those kinds of things. As I've sat in and made these decisions, as we've debated them and delegated them, at what point would a court or somebody else come in and say, it's not really planning and zoning's profession to run these homes. It's not planning and zoning's profession to run a gas station or a grocery store. And we start to put these conditions on to the point that sometimes I think, is this their business or ours? Is this their operation or ours? Where does that divide? Where is enough, if I'm making sense?
Yeah, no, and I may throw this to Jordan here as well for his comment. But I think, first of all, you have to have those areas for standards set in your ordinance. So in other words, you have to say the kinds of things you can consider for conditions are, hours of operation, staffing, all of those things. You can't just decide, well, we don't have any standards for that, but we're going to do it anyway. You have to have something in your code or ordinance. And then as to determine what that should be, rely on other experts, rely on the staff, rely on other people that are involved in the business to give you some recommendations. And if you've got a good staff, they'll go out and they'll find that opinion and that expert and provide it in a report, and then you can rely on that. But, that's go ask some people who know the business what would be a good thing to do, and then base that on that. And then you've got some evidence to base the conditions that you're making.
And I do want Jordan to speak, but just to intervene, I call it the since you asked phenomenon. In other words, we've now required you to come and bring to us your business proposal. And since you're here, it just occurred to me that, by the way, I wish you guys would carry this and sell this, or don't do this, or whatever. And unfortunately, Planning Commission members, Land Use Development Authority members need to understand the only question is, does it comply with the ordinance? If it doesn't comply with the ordinance, then you can adjust and turn it down or whatever. But if it complies with the ordinance, and in conditional uses it does, with reasonable conditions, then approve it. And it isn't subject to individual preferences.
Yeah, and sometimes the problem you get into, if I understand the question right, is when you're talking about conditionally permitted uses, you get into this inquiry of, like you say, who's the expert to make this kind of a decision, right? And it is important, right, for the decision maker to know their limits and to know their expertise, and you're really getting to the heart of the need for the substantial evidence standard. Because, a planning commissioner who is otherwise, not an engineer, whatever they may be, right, in their profession, but is trying to make conclusions that only really an engineer should be making, has gone beyond their purview, right? And they need that's why I think the courts are emphasizing so much the need for these decision makers to support their decisions with substantial evidence that comes from people who are qualified to speak to the issue.
Thank you. Question?
Yeah, so on the Monticello case, just for, I guess, my clarity, was the reason that there wasn't due process rights was just because they didn't have like a de novo review standard at
Yes.
the county level? So if there was that, so the fact that it was just a record review, that's the only reason that they didn't have that?
Yeah, and this is a distinction that the lawyers in the room will, brighten knowing because they understand the distinction and many don't. The state code basically says you have two ways you can review a decision: with great deference to the decision maker, or with a full opportunity for the appeal authority to redo this and, in many cases, avoid a calamitous mistake. And you might have the same result under both standards, but one of them is you're stuck with the record made. When I was a member of when I was the appeal authority for Salt Lake City, for example, if a decision was made by the Landmark Commission or the Planning Commission, then my job was a record review. But if it was by the zoning administrator, then I could hold a de novo hearing and start over and create a new record. We could bring all the other record in, it would be relevant, but I could ignore it or add it or supplement, or we always held a public hearing, in fact. But that distinction is important to know how these things are handled. And in the Monticello case, yes, it was a record review. Okay, so administrative discretion on the record and legal. How do we interpret ordinances? Now we've hit legislative discretion, administrative discretion. This is the third big picture item we wanted to cover tonight. And if you got these three concepts down, gosh, you're in great shape to talk land use law with people who know what they're talking about. So a land use authority shall apply the plain language of land use regulations. If a land use regulation does not plainly restrict a land use application, the land use authority shall interpret and apply the land use regulation to favor the land use application. Now, as one who opines on this a lot, Jordan, would you like to comment on exactly what that means?
Sure. So yeah, through one of the things that we do is we provide advisory opinions, right? And often we're asked to interpret the language of a code. And really it does come down to, okay, what does the language say, and is it clear? And if two people read it, would they draw the same conclusion, right? And if they would, then that's it. That's the decision. That's what you go with. And it's important to make things clear, besides that, and getting to the second point, if two people can read something and draw different conclusions. I once talked to someone, I'll keep everything, very generic, but there was a code in a community and you read it and it just frankly didn't make any sense. Like there was so many different ways that you could have interpreted it. And it was learned that the person in charge had given direction to write the code that way so that if someone comes in and made a request, then we can just interpret it in a way that will benefit the city, right? Bad way of doing business, especially in the land use arena where, because land use regulations restrict property rights, the courts have said, and typically the default rule is people can do whatever they want with their property. If there's ambiguity, if you read a code and it's not plain what it says, then the courts are always going to interpret in favor of the property owner. So local governments, Make your codes clear, make your codes understandable, you know, take it to a few different people and ask them what it says if you have questions about, you know, how it should be interpreted. And if you're getting different interpretations, rework it and rewrite it and try again. So
Did you see how he inserted just that ability to rephrase it so his statement could be, he could illustrate the issue of lack of clarity? That was great. Okay, so we're going to interpret it in favor of the use of property. The best evidence of the ordinance's intent is the plain language of the ordinance. We presume that the city council was deliberate in its choice of words and used each term advisedly in accordance with its ordinary meaning. Where an ordinance's language is unambiguous and provides a workable result, we need not resort to other interpretive tools and our analysis ends. Again, deference by the courts. In every one of these situations, the effort is to try to enhance the dignity of the local decision-making process and support this executive branch or legislative branch function so the judicial branch keeps the separation and doesn't interfere in the actions of the other. So again, that's healthy, that's American, that's the way things have been, and a predictable result. But the justices are often disappointed because given all that discretion, local governments still either don't lay the trail or, you know, cover the tracks, lay down the record like it needs to be recorded, and then the courts can't uphold it or support it simply because the bias is in favor of the use of property.
one other issue that regularly comes up is this idea of intent, right? So if you write something, we often will interpret something, a code one way, and the feedback we get is, well, that's not what we intended when we wrote that. Unfortunately, the property owner doesn't know what you intended either. They only have the plain language to go off of. So that's why the court always says you go off of the plain language and what it says. If you intend something, make sure that intent is reflected in the language that you use.
Good point. So the idea is you have all the discretion. We, the court, will grant you all the discretion to do this the way you wish, but you're stuck with how you do it. So we'll illustrate the next story about interpreting local ordinances with a non-conforming use. And this is a grandfathered use referred to. It's basically an idea where a use was legal when it was created and would not be allowed today, but it has continued on without interruption of at least a year since it was initiated legally. So it's still a legal non-conforming use. It's legal. It's just not conforming. And if someone abandons it for more than a year, then it will no longer be legal. And that's, again, this is a separately protected property right. So here we go with our story. This is not in my backyard story because it says right there on this junkyard, backyard auto. I'm not making this up. It just doesn't get any better. So this is West Valley City. And West Valley City says, we don't like this. It's not, we don't want it in our backyard. This is actually in the backyard of the Rocky Mountain Raceway out on the west side of West Valley. So I've outlined in red Mr. Castor's my backyard auto. So the city says, okay, we're watching, and someone has shown us evidence that you have not used this use for a year, and so we're forcing you to abandon it. This goes to the Court of Appeals, and we won't go through the language the way the lawyers do it. We'll just talk about it as if it were a conversation, but we'll reach the major holding in a more efficient way. So the court may have said, okay, what are we doing? The city says, well, Castor built this use of junkyard years ago, and he's abandoned it, and so we're making him stop. And turned to Castor's attorney and says, okay, what's going on? And Castor's attorney said, well, he's never stopped his use. Read the ordinance. Well, the ordinance says this is what a junkyard use is: to keep or store or sell or disassemble parts. And the court says, okay, city, what do you think? The city says, well, he hasn't disassembled or sold anything. And the court said, So what is it about the word "or" you don't understand? It says keep or store or disassemble or sell. Are you saying he hasn't kept junk cars on his property? The city said, well, of course not. That's why we want him out of there, is that's what he's doing. And the court said, okay. His non-conforming use is preserved because you wrote the ordinance and you used the word "or" instead of "and." So the ordinance, again, interpreted in favor of the use of property. This is the lovely town of Sandy in a better climatic period than we're having right now. Gosh, there's no snow on those mountains. Look at that.
It's during the drought.
Yeah, it must have been. So this is Steve Brown's house. He's right in the middle of this lovely residential area, and he maintains what is affectionately referred to as a short-term rental. He rents his house overnight. Now, this case is, again, 25 years old. If Steve Brown had just taken his concept and called it Airbnb, he'd be a bazillionaire today. But Airbnb was founded a few years after. But Steve and some of his buddies had what they called the Sandy Ski House Association, and they had a website. And you could go on the website, rent a house, and then go up to Alta or Brighton or wherever you're headed and come down and stay in Steve Brown's house. Well, all that's great, but the neighbors are concerned. So the neighbors, there were beer cans. I mean, I'm making all this up, okay? There are beer cans on the curb in the Sunday morning, and the kid can't get the teenagers out of bed because they've been watching what's going on in Steve Brown's hot tub all night. But the city then is asked to respond. The city, by the neighbors, the city goes to Steve Brown and says, we're shutting you down. And Steve Brown hires an attorney, and the attorney says, what has he done wrong? And they said, well, he's operating a lodging facility. It's a commercial operation. It's right here in our residential neighborhood. So they go to the Court of Appeals. And the Court of Appeals looks at the case, and here's the conversation. Court of Appeals. So city, how is he violating the ordinances? Where in the ordinance does it say you can't rent your house overnight? They say, well, it's a motel. And they say, well, it's not a motel, it's a house. But what says you can't rent it overnight? In the city, I'm not making this up. In the case, it says, this is what the city said. Right here in the preamble, it says, the purpose of this ordinance is to create quiet family neighborhoods suitable for family life. See, it says so right there. You can't rent your house overnight. And the court said this. Because zoning ordinances are a derogation of a property owner's common law right to unrestricted use of his or her property, provisions therein restricting property uses should be strictly construed, and provisions therein permitting property uses should be liberally construed in favor of the property owner. This is biblical text. Have you noticed? I mean, when I was in law school, they didn't number the paragraphs in those opinions. And now, as particularly in the culture I live in, those look like verses to me. But they number those now, and this is the common law doctrine. And the Court of Appeals has stated this 6 or 8 times, repeated this language. And the Supreme Court has not lowered itself to quote the Court of Appeals, but they've said that in so many words, basically. And then the legislature picked up and said, okay, we're saying it too. And you heard that in the legislation earlier, the state statute. So the idea is we can write the ordinances the way we wish, but our ambiguities will be resolved in favor of the property owner. Okay?
And very often, like in the Castor case, you don't even have to go to ambiguity, right? That's just plain language and what it says. Again, make sure that you're writing your ordinances clear and that they say what you want them to say. So,
thanks. Okay, next case.
You talk about how Sandy resolved this.
Oh, Sandy, how did Sandy resolve this?
Well, so the court said, you have to be plain. And Jordan just talked about write your ordinances and say what you mean. So Sandy rewrote their ordinance and said you can't have short-term rentals, and they defined short-term rentals as 30 days or less in residential zones. Then the courts have said, that's okay, you said it. But they hadn't said it at the time of Steve Brown's. And I think, didn't they have to wind up buying Steve Brown's property and settling?
They didn't have to. They could have let it go as a non-conforming use, but they did end up buying Steve's property, as I understand it. So again, it's reasonably debatable that it promotes the general welfare to restrict short-term rentals. So have at her. Just don't read that in an ordinance that doesn't say it. That's the point. Okay, Springville Citizens v. Springville City. Interesting contradiction in terms. It's actually Springville Citizens for a Better Community. And then again, an organization created to challenge a land use action. This case is significant and quoted relatively often. This is a subdivision on the hillside after it was built. When it was just platted, the residents sued, organized themselves and sued, saying that the city hadn't followed its ordinances. So I will again paraphrase in the interest of brevity and, way too much humor. But the court may have said, okay, what's going on? And the resident said, well, the city didn't follow its own ordinances. And we made our appeal. We filed it within a timely basis. We're properly before the court. And we're saying they didn't follow their ordinances. And the court turned to the city and said, okay, did you follow your ordinances? And the city said, well, substantially. And the court said, what do you mean, residents? They said, well, here's two things they didn't do. They have a rule that if there's a canal across the property, it has to be on the plat, and the canal company has to agree on the plat that it's properly drawn. And the city might have said, well, okay, here's a letter from the canal company. It's properly drawn. And the citizens may have said, well, okay, but it also says you can't change the conditions imposed on the subdivision by the planning commission. So when it comes to the city council, you can't change it unless you send it back to the planning commission. Well, they made some changes and approved it without sending it back to the planning commission. And the city man said, well, here's the planning commission minutes. It was approved after this suit was filed. It's all fine. The planning commission loves it. And then the court said, okay, city, you call that substantial compliance? And the city said, yes. And the court said, okay, who wrote the word shall in the ordinance? Who put that word in there? The city said, well, we did. And the court said, well, what does that word mean? And the city may have said, well, we didn't mean it to be nitpicky. And the court might have said, well, then why did you put a less than nitpicky, why did you put the nitpicky word in the ordinance? You say shall, we'll take you at your word. So your ordinance was not properly, this subdivision plat was not properly adopted. And basically, point well taken. And then the court turned to the citizens, who at this point may have thought, okay, we read this part of the opinion, we're happy, and said, so what? And the citizens maybe said, well, they just didn't follow their ordinance. And the court said, no, so what? This is an important ruling. The Springville citizens' ruling is, if you aren't injured personally by this decision, you have no standing to challenge it. So you show us how it made any difference in your life that the canal company hadn't signed the plat. He said, well, the plat wouldn't have been approved and it wouldn't be built about. No, that's not the question. You're raising a narrow question. What difference does it make in your life that the planning commission didn't sign the plat? And of course, the case was thrown out on that basis by the trial court and the subdivision was built. So the rules are basically we need to follow ordinances, but they can only be challenged by people who are actually harmed, different than the community. Comment?
Well
I'm
said.
preempting all the conversation, sorry. Okay, so they're mandatory. Municipal authorities are bound by their terms and standards and are not at liberty to make land use decisions in derogation thereof. Their own ordinances. Once they're written, we all have to follow them. And then the standing is here, and you've got that in your printed materials. An adversely affected party is the only one who has standing to appeal a land use decision. Again, you have this in your materials. Which leads us to this point. This is the lovely environs of Salt Lake County. I wish it was in color. When I got this drawing or this aerial photograph some years ago, it was only available in black and white from an aerial photograph outfit. But it's lovely. There's a county street running through this area with lots of landscaping. Up in the upper right-hand corner, you can see some parking, indicating there is commercial development on the horizon. This is not in the bucolic outskirts of Salt Lake County. This is, in fact, not the dead center. This is the live center. This is 72nd South and 10th East, better known today as the Family Shopping Center. Walmart, Bed Bath & Beyond, Mr. Mac, and Ross Dress for Less. The same property exists in the center of both pictures. Mr. Croxford is in his 90s. He has some very loyal daughters who vigorously defended his right to live his life in peace and not be surrounded by commercial development. So they went to the hearings, they protested. Now these guys have that substantial property right. They have standing. This affects them. Let me show you how. This is what used to be a county street going to the Croxford property. This is the county street sign. This is 72nd South Street, by the way. If I stepped back a foot after taking this picture, I would have fallen into the Walmart trash container. So the residents, the Croxford family, and the daughters' married names were Culbertson, Mybos, and Johnson. So we have cases in those names. But they challenged the county's decision, saying, you violated our rights. We have protected interest here. And the county might have said, well, like what? And they said, well, you have an ordinance that says County Street has to be 50 feet wide. Is that 50 feet wide? When the court asked that question, the county said, well, it's not a street. We closed it. And the court said, well, where in the ordinances do you define a closed street? The county said, well, it's not there. Again, I'm grossly paraphrasing the strategy that was discussed here. And the court said, well, if it's not a closed street, is it private? And the county said, well, no, we own the street. I mean, they certainly wouldn't have given it to the Croxford family. And the court said, okay, if it's a county-owned street, it's a county street. It's subject to the 50-foot rule. You can't run a wall down the center of a county street that's supposed to serve this family. In fact, we don't know how a fire engine, an ambulance, or a garbage truck are going to get into that property. So you have violated these individual rights by these property owners. This is what the court said. Where the encroachment is deliberate and constitutes a willful and intentional taking of another's land, equity may require its restoration without regard for the relative inconveniences or hardships which may be result from its removal. Tear the buildings down. Utah Supreme Court, 2001. And you have this in your materials, other parts of the case. On the record before us, the uncontested facts support one conclusion, that Hermes, the developer, acted willfully and deliberately when it constructed its buildings after plaintiffs put both Hermes and county on notice that the proposed construction would violate county ordinances. By allowing Hermes to proceed, the county stepped into the quagmire we condemned in Springville Citizens for a Better Community v. Springville, where we emphasize that local zoning authorities are bound by the same terms and standards of applicable zoning ordinances and are not at liberty to make land use decisions in derogation thereof. This is a Deseret News diagram showing Ross building to be replaced with smaller boutiques, cul-de-sac to be added. Another thing the Culberts and Mybos Johnson daughters claimed was the conditional use permit required everywhere the project abutted a county street, there had to be 20 feet of landscaping. Now, I showed you a picture of the street, and the weeds growing there are not landscaping. So they basically not just tear it down, not just build a cul-de-sac, but move the buildings 20 feet away from the finished street. Now, as luck would have it, or fate would have it, this drug on so long that, in fact, Mr. Croxford did not survive. And when all the dust settled and it was over, before the Ross did move out of the building, but before it was demolished, the daughters worked out an arrangement. I do not know how many zeros there were on that check. But this is one of the best examples we have of local government simply not following the rules. And again, this was a cash cow for the county. They were going to have terrific benefit from the development of the family shopping center. It's now been incorporated into Midvale, so it's not the same. But they were strongly motivated, and the court basically said they did an inappropriate shortcut. And this case also illustrates how we can have, very astute minds on all sides. The attorney who represented the Mybels, Culberts, and Johnson family was appointed a federal judge by Obama, and his nomination did not make it through a Republican-controlled Senate. But under the doctrine of private attorney general, it's called, hundreds of thousands of dollars of legal fees were awarded against Salt Lake County. And of course, Hermes ended up paying, I imagine, a significant sum to get rid of the case. But again, the idea is we follow the rules. So administrative decisions will be upheld if there's evidence in the record and the decision is otherwise legal. Comment?
I think you covered it well.
Oh, no, I'm talking too much.
Sounds good to me.
Okay, next item for you guys.
Question.
Yes, sir.
Regarding cities not following their process, I think we've all seen cities where we look back at something and we find an issue. At what point would a person have standing to contest an issue that something didn't go through the process? Or at what point can the city do something about fixing something that was 5-10 years ago?
So typically, the appeal windows, it all depends on the appeal window, right? And the appeal windows are very narrow for land use decisions, and the courts have said that the purpose for that is so that, citizens and property owners and government and everyone has certainty in decisions that are made, right? So it is important that if there is an issue that has arisen and a property owner or a local government or someone has failed to follow the mandatory provisions of the ordinance, there is going to be a window within which that decision has to be appealed. Otherwise, it's not that it becomes legal, it just becomes final and unappealable. And so at that point, there's just no remedy for the rule, essentially. And again, that's so that it's kind of the whole idea of a rule of repose, right? So that the situation can stay the same if no one has identified it as an issue and things aren't being brought up in history that are causing everyone more costs and those types of things, if that makes sense and addresses your questions.
And in this Mybus case that Craig just told you the story about, they were diligent. They filed every appeal they needed to appeal, and they kept this, in front of the county and others saying, you're not following the rules. And the county just kind of ignored it, and it took years to resolve, but they had kept their rights alive by making sure that they hit all of those appeals at the time that they needed to.
Which brings up a really important point of that, as far as the land use process is concerned, if you have a concern about what's going on, then you need to pay attention. No one's going to tell you what's going on. You have to pay attention, and you have to make sure that you do preserve your rights.
That is so true. Okay, so we're going to switch gears again. So we've talked about the processes, we've talked about following the rules, we talked about administrative, legislative decisions. One thing that comes up enough that we wanted to spend a little bit of time on it is imposing conditions on development. And this raises the specter of a constitutional issue because of the one thing that we get involved in more than some that actually is a constitutional question is the imposing of inappropriate conditions on approvals. So I'll have Jordan take a minute and give some context here.
Okay, so we're talking about conditions on development, what we refer to as exactions, and Craig just recently took to task or took upon himself the task of reading all of the opinions that our office has done, a few of which that he wrote, but many that have come since. And this topic,
And gotten better over the years, I assure you.
and this topic is the topic that we address the most, or that is raised most often with our office, is whether or not an exaction is lawful. And essentially, the long of the short of it is that whenever development occurs, that development has impacts, and it needs services. It needs roads, it needs water, sewer, all the utilities, storm drains, different things like that. And essentially, it's appropriate for local governments to require development to pay its own way. So whenever the local government needs to provide services to a development, and those services are in the end going to be owned by the local government, the question is brought up. Well, okay, when I develop and the city makes me build all this infrastructure and turn it over to them, does a taking occur? Does a taking of private property occur without compensation? And kind of, where it lands. So here's kind of the legal standard, but what, in layman's terms, essentially what it says is that you can require development to offset its own impacts, to pay its own way. But, and as long as it's only doing that, then constitutional takings concerns are not raised. The minute, though, that you start requiring property owners and developers to pay for impacts beyond their own, that's when you start raising taking concerns, and that's when the Constitution is violated and an exaction becomes illegal, essentially.
Super. So there's two basic tests. One of them is this exaction within the authority of our group to impose? And the second one is it proportionate? It is within our authority. Then now we're imposing a burden that's roughly proportionate. I think we have a question, Doug. If you could hand the microphone to this gentleman, and Karina has it. Right over here. So again, two parts to the analysis, and it gets to be relatively simple as we get into it a little bit.
So this is kind of about fees and the things that occur that the city, if you have a development comes in, you require curb, gutter, sidewalks, paved streets, connection to the sewer, water lines. Are you then allowed to also include a very high impact fee per door, or have they already met that definition?
So, okay, good question. When we're talking about impacts, you have, we make a distinction between project improvements and system improvements. Project improvements are those improvements that clearly serve only the development being proposed, and then system improvements are those that serve the greater community, but each new development contributes. So if you have one community, or one development, if you require them to build a system improvement, odds are you're having them address impacts beyond their own, because they contribute to that improvement, whether it's an arterial road or a water tank or a trunk line of a sewer or whatever. They contribute to that, but they're not solely they're not the only ones who need it. So that's where impact fees come in, right? Is you're having someone pay their proportionate share of impact to these system improvements. And there's an Impact Fees Act that requires local governments that if you're going to impose impact fees, you can do that, but you have to create a facilities plan, and you got to say, okay, these are the facilities that we're going to need for new growth. And then you got to also do an analysis that shows, that puts out a number, basically, right, that shows what the fair share of each individual is. And again, as long as they've done that, as long as they've included experts and provided evidence to support their fee, in other words, as long as the fee is reasonable, right, based upon.
This is above and beyond all the extra to get their subdivision in place.
Yep, yeah. So this is above and beyond what they've done to put their project in place, and that's right. Yeah. So you can have a development, again, lawfully speaking, local government can require development to offset its impact as it relates to project improvements. You can build all those, and then you can also charge them an impact fee to account for their fair share of impact to system improvements. So, yeah, again, assuming that impact fee was calculated according to all to the procedures laid out in the Impact Fee Act, and it's supported by evidence, and they can show that, yeah, you know, these are the facilities that we need, and this is their fair share contribution to that facility, then yes, they can require you to do both project improvements and pay an impact fee.
With a couple of considerations. Number one, it must be provided for in the ordinance. If the ordinance doesn't require it, then their application complies with the ordinance without this exaction. So they can get approval because it complies. So the ordinances need to be carefully written to provide a good balance and some ad hoc review of proportionality in each situation. And then you've got a solid basis to impose conditions and exactions on development. But the burdens imposed, let's say, for example, well, let me just tell you a story. Yeah, I mean, I got a story. By the way, before I do this, could I just take a moment and thank Salt Lake County for being the source of so much good law? So the questions are, do we have the authority to impose this requirement? Does it address some burden imposed on the community by the development? And is the burden imposed on the development roughly equivalent to the burden the development imposes on the community? Okay, here we go. BAM v. Salt Lake City County, excuse me. This is 35th South heading out toward Magna. Now, right now it shows at the time our saga begins, 3 lanes, center turn lane, 1 lane each direction. But this is 35th South, you know. This is the arterial highway, the section line road headed west. So BAM comes in and wants to build this subdivision. And this is the plat. And it comes back with a red line. You know, they all come back with red lines. This one has a red line. And the developer may say, what is that? And the county would say, that is the land you're going to give to the city. County, I'm sorry, I mean, I worked with Salt Lake City. They're immaculate. I was Salt Lake County. Okay, so widen the road. We want a 65-foot half width. Move the telephone poles, build curb gutter and sidewalk, and then you can put in your screening fence. And this is what the edge of the development looks like. This is where it hits the rest of 35th South. Temporary. And BAM they didn't think this was really that good an idea in the first place. They went ahead and did it, and in a situation relatively rare, the county gave them permits without resolving their outstanding complaint, and BAM preserved their right to challenge it while they were building it. This went to the Supreme Court 3 times, and by the way, the court was not happy. Bam, bam, bam. In fact, when they made their final decision, they said, by the way, we are never considering an appeal related to this matter again, period. End of opinion. I'm not making that part up. So BAM said, look, see that yellow house? UDOT's going to come along and widen this road and pay those guys money for their property. But we have to dedicate our property, move the power lines, put in the curb and gutter, everything, storm drain, the whole rigmarole. And the court said, I'll get to the point here. What burden? Salt Lake County, you haven't put on the record how this is justified. So you got to go back and do it over. And in this case, the county had also preserved somehow the opportunity for another look. So the county actually hired an expert, traffic engineer, they're available, to determine what is the impact of an average house on the system of streets. And the engineer came back and said that it was some number, I forget, that it was something like, let's say $8,000 a house. And there are 40 houses in the subdivision, rough numbers. So this has a $320,000 burden on the community, proportionate for the whole system of streets. And then the court may have looked at BAM and said, okay, what was the bill? And the BAM said $187,000, and the court said, go away. So I would say that the impact fees have to be considered in the analysis. So if BAM has spent $187,000 and another $200,000 in impact fees, then they would have been, their burden would have exceeded the burden placed on them would have exceeded the burden they were placing on the county by the county's own rules. But because the county proved substantial evidence in the record that there was $320,000 worth of burden, and they'd imposed on BAM a burden less than that, there was no takings issue. And the county, in fact, had a legislative mandate that when development occurred on arterial highways, the developers would be required to provide this arterial highway width. So everything was approved. It was legitimate. Have a comment on this, Will?
That's good.
Wilf.
Yeah.
Okay.
You're doing a good job.
Yeah. So here's just a quick example of what didn't work. Guy came in and he said his mother owned 40 acres. He wanted to divide it into 2 lots so he could build a home and be next to his mother. And he went to the city, and the city said, that's no problem. You just bring us a plat. And they redlined it with this dotted line around the plat. And the fellow said, okay, what's the dotted line? And the city said, that's a 33-foot wide area where as soon as your neighbor, sign this. And it just simply provides that when your neighbor develops his property, any side of your property, you're going to dedicate 33 feet to the city and build the improvement, the road on that property when that occurs. And I, as ombudsman, called the planner and said, excuse me, and I mean, I don't think this is legal. And the planner said, well, we're just asking. So, I mean, this is just over the top overreach. And the ordinance might say, when you develop property, you have to provide opportunity for others, but that ordinance is illegal if it's applied illegally. So you might have an ordinance, like in the BAM case, that is perfectly legal, but let's talk about the little yellow house next door. If they were required to build their portion of an arterial highway for the next 100 feet simply to add a garage or, put a second unit, an ADU, that would likely be disproportionate. So these are ad hoc individual analyses that are done on each property's basis, and it has to be shown for each property, and the burden is on the city or the county to do the math to begin with, for what that's worth.
What the city could probably do in this situation is when he asks for the permit to build that house, they charge him an impact fee. That would be proportional to what that total cost of the improvements is. For one house, it's going to be something a lot less than all of the cost of the improvement. And they could charge him that because he's only building one house. In the BAM case, they were building 40 houses, and the impact came to $300 and some odd thousand, and their cost of improvement was less than that, so that was fine.
And one issue that we regularly see is a community will say, well, what Craig said is our ordinance allows us to do it, right? Our ordinance says that this has to be done. But the red flag raises when the property owner asks, is that necessary to provide services to my development according to the ordinances, right? And so you got to look at on an ad hoc basis whether or not it's only requiring them to offset their own impacts. Otherwise, no matter what the ordinance says, if as applied to that property owner, it doesn't comply with constitutional requirements, then you can't impose it.
For what it's worth, that's an issue that comes up. And like Jordan said, it's the biggest issue. It's the plurality. It's not majority of his cases, but it comes up a lot. And it's a really good opportunity for the Ombudsman's Office to help mediate a solution, which is what the Ombudsman's Office often does. Okay, so what is an applicant to do? 1, provide a complete application and pay the fee. 2, demonstrate that the application complies with the ordinance legally and factually. 3, if denied, appeal the land use authority's decision to the appeal authority or ask the appeal authority for a variance. If denied, appeal the appeal authority's decision to the district court. So there are steps to be taken. And the only appeal is based on it not complying with the ordinance. The fact that it complies with the ordinance, I'm still turned down. That the conditions are illegally exacted, or that the conditions imposed on a conditional use are not appropriate, or the denial of the conditional use wasn't based on substantial evidence. But this all goes all administrative issues go to the appeal authority, not directly to the court. If you miss the chance to go to the appeal authority, you miss the chance to go to court. The court has no jurisdiction.
Can't be referended either.
You can't be referended either because is that a verb?
I made it up.
Is not subject. It can't be referred to the voters because it isn't a legislative act. So when must you appeal? This is Brendel v. Draper City. Brendel owns some land on this slope. The Draper City ordinance said if you're over a 30-degree slope, you need the planning commission's permission to build on your property. And this is an old case. The language is way obsolete, and I'm sure not in place now. So someone went to the planning commission and said, can we build? And the neighbors came out, and the planning commission said no, and they let it go. And then later, someone came and asked if they could build, and the neighbors weren't there. Now, we don't know why the neighbors weren't there. They didn't see the notice, but it was properly noticed, and the planning commission may have said, where are the neighbors? And the applicant might have said, who knows, well, if they cared, they'd be here. And the planning commission might have said, well, if they don't care, we don't care, go ahead and build. And that none of that is true. But what we know is that Brendel got his permit and waited a little while and then started digging. And the neighbors came unglued and came into the city council, and the city council red tagged the project and said, stop it. And Brendel said, I have a vested right. I mean, I have an approved permit. And the commission said, yeah, but, and I'll use a legal term, we've been snookered. That is not in the case. And it goes to the Court of Appeals, and the Court of Appeals, again, conversationally, says, well, what's going on? And the city said, well, we think the planning commission was misinterpreted why the neighbors weren't there. And the court said, well, okay. And what's your deal, Mr. Brendel? And Brendel said, well, all this is wonderful, but it's been more than 30 days since my application was approved, and I've got my permits. I'm going to town. They red tagged me. And the city said, well, we had to stop it. And the court said, well, but you missed the deadline to appeal. And the city said, well, we're the city. And the court said, well, yeah, you wrote the ordinance. It says in there 30 days. Did you mean 50? Was it a typo? The city said, you mean we have to appeal within the time in our own ordinances? That the city has to appeal? And the court said, yes, next case. So it applies to everybody. Draper did not appeal within the time. I mean, you couldn't say, well, we didn't know what it was. It's the city planning commission that made the decision. And so, again, everybody's subject to the rule. And the goal is to provide some predictability in land use decisions. Question, comment?
And we may not have the time, but it would be interesting for you to explain how somebody who had a question about an appeal and talked to the city, and the city kind of encouraged them not to file an appeal, but then they finally decided, well, we probably should have appealed, but then it was decided, doesn't matter, you've missed your appeal period.
That's true. Do you get jurisdiction questions like that often?
Yeah. I mean, again, it's unfortunate, but I don't know that I have a good answer other than, like we talked about before, you got to protect your own rights. And there are certain cases and situations where the law does require a property owner to probably be more sophisticated about a situation or knowledgeable about a situation than they should be expected to be. But the reality is that's kind of how it is, unfortunately. And so, you know, if you, what I always tell people is if you have any question about whether or not you do want to file an appeal, then get it in and pay your fee, file the appeal, and then decide later, but do not let that time period pass without you making a decision about what you want to do.
And some lawyers, in abundance of caution, are stuck with a couple of, I mean, like, let's say the city council is the land use authority, and it's a development agreement or a PUD, and we don't know for sure. Is this like Cottonwood Mall? Is it like a legislative issue? Or is this like a site plan review and it's administrative? A wise attorney would file a local appeal and file in the district court. Both. And stay one until stay the court action, but at least get the appeal filed. Don't even have to serve the complaint until it's time to do that. But preserve all those rights. I had a poignant case where a fellow called me and he said, I went to the planning commission, the planning staff. I wanted to appeal my subdivision. They said, you can't, you have to go to the city council. We won't take the appeal. So he went to the city council said no, and then it goes to court, and the court said, you didn't appeal. He said, well, no, the planner told me I didn't have to appeal. The court said, we're sorry, but under laws of agency, local government's not responsible for the acts of its agents. It's not like corporate law. Municipal entities are not responsible for the conduct or statements of their municipal employees except for a majority of the city council. I mean, that's who binds the city. Nobody else does. So you have to know this law yourself. We assume people understand the law, and if they don't, it doesn't matter who told them different, it's over. So, not a happy story.
Right, that's it.
But we're here with the truth and reality tonight to try to get everyone on board. Okay, we are down to the last 15 minutes, and we're going to be philosophical for a minute. I want to talk just briefly about the dignity of a citizen and what that opportunity is before the decision-making process of land use. Again, what's the purpose of all this? We, of course, want to create great communities. We want to conduct government in a way that in today's harsh climate, where there's so much division and so much stress and so much abrasiveness, that we don't contribute to that we try to reach out and let the process work in a conciliatory fashion. Utah's the only place that has an ombudsman's office. I think there is a Utah way of doing things. And I think we've seen it talked about in the media, and I believe that's true, that we have opportunities to diffuse the tension, and we could hold a series of seminars on how to do that, different techniques. But one of them that I would urge that's really quite related to land use law is that we preserve the due process rights of individual citizens. And without getting into the details, I think we err on the side of listening and trying to involve. Basic due process is the right to be heard, the right to notice when a decision is being made that affects our protected property interests. This isn't public notice generally. But if someone comes in with an application for a variance that's a side yard and they're right next to my property, then I have an interest in that and should be notified and heard on the subject. So it's the right to confront witnesses, and that's a fancy way to offer competing evidence. And also the right to an impartial decision maker. Those kinds of things are basic to our understanding of government and the way it ought to work. And so we just, in our land use context, want to raise those issues and see if there might be a question or a comment about those items. Any thoughts?
Yeah, I mean, when I talk about this with people, it's honestly to a degree largely shocking how much our system relies on, number one, and I think most of the time people do, but people acting in good faith on both sides. Not trying to be deceptive, not trying to pull wool over eyes and those types of things. And then also engendering an atmosphere of trust, right? And the way that you do that is through the due process, right? Providing people notice of things, telling them what they need to know, even though you may not be legally obligated to, and making sure that everything in the process is on the up and up. It's important, and it frankly leads to a lot fewer disputes that you would otherwise have.
Thanks.
It's important too that we help people to understand the process and the distinction, particularly like between this legislative and administrative. People get it that they can come to a public hearing and spout off. You know, they say they like this, they don't like this, this is a great idea, this is not a good idea. What they don't understand so much is in the administrative process, their opinion doesn't matter anymore. You know, it's about the facts. Does this application meet the requirements of our code or ordinance? And we need to help people to understand that. Because otherwise they come to the meeting, you know, if you allow them to say something on an administrative matter and then you wind up saying as a commission member, and the commission body saying, okay, well, great, thanks for your comments. Now we'll make a motion to approve it. And what do the citizens usually do? They go, you dirty buggers, you didn't listen to us at all. Well, they don't understand that you have an obligation to follow the law, and if the application meets the requirements, you have to approve it. And helping the citizens to understand that really will benefit everybody.
Thanks. So, yes, we have a question here.
Okay, so taking that into account with public hearings, are there any cases where you want to hold a public hearing for an administrative issue, or is that just causing frustration for the public?
Well, I think in most cases it just causes frustration. If you're around tomorrow, we're going to have a session on public participation. And Gary Crane and I, Gary is the Layton City attorney and works a lot at the legislature. We're going to kind of propose this idea of if you're going to have hearings on administrative items, make them a different kind of a hearing. Not a general public hearing, but something that's more like, in some places it's called an evidentiary hearing or administrative hearing, so that people will understand there's different rules that apply here than your basic public hearing where you get to come and say whatever you want.
And Will's session will be really good to hear on that. Another offer, sometimes we artificially ratchet up the stakes. For example, the artificial idea of some deadline, like we're going to hear the case, hold a hearing, decide tonight. Can we avoid that? If we're going to hold a hearing, don't make a decision at the end of the hearing and take it under consideration. One of the best processes I was ever involved in was in Eastern Summit County. I'll praise them. Eastern Summit County Planning Commission. And there was you'll love this, there's a subdivision that was vested 23 years before it was heard. So it's 23 years past. I mean, the general plan had changed twice. And it was never allowed. I mean, it'd never be allowed today, but it was vested. And so this chairman of the planning commission was not sophisticated. He wasn't fancy. He didn't come in, dressed in fancy apparel. But this is what he said. He said, okay, I understand everybody cares a lot about this, and we do too. So this is what we're going to do. Developer's going to explain the situation to us. The staff is going to respond, and then we are going to sit here and listen to everything you have to say. The developer is going to take notes. And at the end of the time, the developer is going to stand up and write down the questions he heard you ask. Then you can comment and make sure you got the questions right. Then we're going to meet in 2 weeks, and the developer is going to answer the questions. Then you're going to answer, you're going to see how that we went. That was approved without a public, nobody came. To the third meeting, nobody came. And the staff reports were transparent and published, and everybody knew what was going to happen by the time the dust settled, and everybody understood why. And it was therapeutic. Really a good process.
That's great.
Oh, no.
You covered it.
Okay. Well, just a quick story. This is Dairy Products v. Wellsville. This is a dog food factory. Wasn't started that way, but it ended up as Dairy Products. Sounds like, we do milk. They do dog food as well as other things. So the neighbors were not happy with this, and there was a common law nuisance issue here. I mean, you don't have an easement for odor across your neighbor's property just because it's good business. And I tell this story in part because it's Wellsville. This is the city hall at the time. This is not Manhattan. This isn't Boston. This isn't even San Francisco. This is a group of people in a small community trying to do the best they can. This went to the Supreme Court, which upheld that local decision on every point, because they had good legal counsel. And the opposition, the Dairy Products folks, said this is a business license review where they were going to revoke the business license. They had evidence in the record to support the revocation. They heard the opposing counsel. They had every chance to cross-examine the witnesses and talk about it, even in the informal public hearing session. They had every opportunity to present their own evidence and provide it. And Dairy Products Council also argued that the council was biased because they didn't look like they were interested, and their body language said they didn't like the stinking plant. And the court said, oh, for heaven's sakes, come up with a better argument than that. And Will's vindicated on all counts. So it doesn't have to be that sophisticated a place. Everybody's entitled to do this right, and any size community can certainly do it and survive scrutiny. Wise decisions can be made during the process and be upheld when challenged. Okay, so let's talk a little bit about what we do. What is the Office of the Property Rights Ombudsman, Jordan?
So the Ombudsman's Office is a neutral, independent state agency that is here to provide dispute resolution services as one of our roles. And we do that in the areas of eminent domain and land use. So in eminent domain, our primary dispute resolution tool is mediation. And anyone who has a takings claim or a concern over an eminent domain matter or some sort of a takings issue, we encourage you to reach out and contact us and talk to us. And we can let you know if we can provide mediation to bring the parties together. Again, it's voluntary. Well, voluntary for the property owner. The local government is expected to participate, but we always have good experience with them wanting to participate and go through the process. So if you have an issue like that, give us a call and we can let you know if we can help to mediate and provide those services. On the land use side, if you have a legal question that comes up, then you can request an advisory opinion from our office, and we give you some direction about what a court would say, what we feel a court would say, and it acts as a dispute resolution tool to help the parties reach a conclusion. And through that process, also we can sometimes mediate the situation if it's appropriate and makes sense. Another thing we do is we feel like the best dispute resolution is training often, right? And so we go around, we provide trainings. Local communities can request that we come to you, to your planning commission, to your city council, and we can provide individualized trainings, whether it's a Q&A or on a specific topic or otherwise. We just got funding and hired a new training director, Rob Terry. Raise your hand, Rob. He's in the audience here. And one of his jobs is to help coordinate training efforts of all the different entities and all the different interests in Utah. So we're excited about that role and how it's expanding and growing. But yeah, give us a call if you think we can be helpful in either providing training or helping to resolve disputes or otherwise.
Thank you. Appreciate that. So there is a webpage, and on that are all the advisory opinions. And then on the Utah Land Use webpage, which we'll show you in a minute, are an index to all those decisions. Hope that's of use. The Land Use Academy of Utah, that is luau.utah.gov. Training videos. Tell us about Luau for a second, Will.
Well, Luau was something that was organized a few years ago, and it is mainly handled by the League of Cities and Towns, but there was some funding that was provided by the state, and it is an entity that really just kind of puts forward land use information and has some good videos on it, has some good resources and some information about land use and how it works in the state of Utah. It's a great resource, something that will provide some additional information.
Super. And then we have the Utah Land Use Library. So this is utahlanduse.org library. This is where the advisory opinion database is. We have a topical review of land use regulation. As I mentioned, the entire ground rules book is there for downloading. And we are in the throes of doing an update. Those who received a copy tonight have a sheet inside the cover of the 2023 update. With the newest books at Amazon in a couple of weeks will be updated, but what will be online will be updated as well as the update. So this is the general overview. We also have summaries of the law, and with the help of the Ombudsman's office, today we handed out a pamphlet, some thickness, on transferable development rights. Tomorrow we will hand out extended legal treatises on the process of land use applications, how to update the land use ordinance, short-term rentals, on accessory dwelling units, and on public participation. So we'll have a total of 6 published this time, all of them online and all of them handed out to those that attend our sessions here. So we're trying to build a volume of land use expertise each of them written by a separate expert in the field, an accomplished planner or attorney, just to provide the case law, the landmark cases that help us understand that, and then to provide insights on best practices. And we have another dozen of these in the works, things like exactions and referenda and all those things. Again, a treatise on each one of those available. Video of our conferences, including this one, and each one, we'll do a video of a training on each of those topics. And then we'll be updating the Utah Law of Eminent Domain, which is another thing we publish. So anyway, we have all that in the works, and we hope it's all helpful. There's never been a better time when the legislature has been more help in getting the word out. And again, let me thank the Ombudsman's Office for funding this program tonight. We appreciate the Division of Housing and Community Development and their help with this conference. And thanks also to the Southern Utah Home Builders, the Southern Utah Bar, and the American Planning Association, particularly with this conference. They've been lots of help and very much entitled to appreciation for our time together. If this sounds like the end, it is.